Yes, Mr. Gansman. Are we on to number 3?
Very nearly. My lady, my lords, I told you just before the short adjournment that the detailed proposal actually was agreed by Hull underwriters and SKK, the managers. It was actually agreed by 1218 UTC on the, and we'll look at some documents later, but I'll give you the references at any rate. On the 26th, I just ought to tell you the references as to how they got the agreement. Captain Sen sent the agreement, the full commercial proposal, the whole package, to Mitsui at 2224 on the 25th. That's S1 tab 60 at the bottom of the page, page 125. And Mitsui passed it on to SKK at 2249 on the same evening, and that is tab 59, page 124. And of course, that was their morning, so they had the whole day and reached agreement by 1218 UTC, which is, I think, 9:18 PM. Got that right? Does that sound right?
That's right.
Right. Third point. Third main point. We can now see that a complete detailed wreck hire contract was available for agreement and signature by 2140. Its pages 100 to 120 in the bundle. Why does that matter? This is not a case, and there are plenty of them in the books, where an outline agreement is reached and the parties or their lawyers then have before them the lengthy task of drawing up the formal contract. In that sort of a case, it can be said, sometimes with force, well, the parties cannot have intended to leave over putting their relations onto a contractual footing for that long. But from a drafting point of view here, there was nothing more to be done. Of course, there might have been counters or negotiations on the basis of the draft, but the draft had been prepared as a draft, a complete draft. As Smit themselves said in a passage my learned friend read on page 86, the necessary preparations are done and we are ready to spring into action. So if you read owner's skeleton at paragraph 33, in our respectful submission, it's quite wrong to talk about the parties, quote, ultimately, unquote, drawing up a wreck hire contract, which would, quote, eventually, unquote, supersede what they say was the 26th of March contract. The whole thing had been done. And it obviously distinguishes cases where the work lies all in the future at the time of the alleged initial contract. Fourth main point. Solicitors were already retained and known to be retained on both sides. Just some references at the bundle S1, pages 66, 69, 133, 214. And there are also references in the judgment. So we've got solicitors known to be retained on both sides. It's also expressly contemplated that the contract will be, quote, signed at the earliest, close quote. That is Captain Sen's email to Smit on the morning of the 26th at 10:32, S1, tab 78. And there are numerous references to signature in the documents. Now, what's the significance of that? My lady, my lords, where solicitors are involved on both sides, and a detailed agreement has already been drawn up, and it is contemplated that the agreement will be signed, the normal inference is that no binding contract comes into existence until at least there is full consensus on the terms of that agreement. It's unrealistic and not necessary to say that you have to wait until the thing is actually signed In a particular case, that might be the right inference, but I'm not going that far, and I don't have to. But there has to be full agreement on this formal agreement with solicitors involved, signature contemplated, and detailed terms. The proposition I put forward is an extrapolation, a simple extrapolation from the statement of Sir Andrew Morritt, Chancellor, in the decision of this court in Cheverny and Whitehead Man. It's tab 5 in the authorities bundle, and it's at paragraph 45, and I don't need to take you to it. A fortiori, that is the case, when it is contemplated that the process can be finalised within a very short time, and when the subject matter of the contract is relatively complex. Fifth main submission. The two emails on which the owners principally rely, 1135 and 1140, exchanged between the parties, themselves expressly recognised that the key contractual document was the completed wreck hire contract, the one referred to in the commercial proposal. And both emails were expressly claused, in the bill of lading sense, accordingly, qualified. That shows, what other things also show, that the parties' agenda remained exactly what it was. Now, let's just spend just a moment on what was actually going on the morning of the 26th. What was at issue between the parties? Well, actually, it was one thing and one thing only: the reflotation bonus. And what the parties were doing was trying to reach a landing on that, because if there was no agreement on the reflotation bonus, it was hard to see how they could reach agreement on anything else. That was obviously important. So it's a necessary step on the way to a contract. But my submission will be that they weren't contracting, and it wasn't a sufficient condition for a contract. Now, Smit had introduced the idea of a refloating bonus in their proposal at 12:03, the first commercial proposal, on the 24th of March. Owners had failed to provide any substantive response to it until 08:16 on the 26th of March, 44 hours later. They'd said, apart from saying that they would revert after a meeting, they'd said nothing about it. And when they did revert, of course, the revised commercial proposal revised the reflotation bonus because the services had expanded, probably. And so that instead of being 25%, it was 35%. But the point is that when owners did come back substantively at 08:16 hours, they didn't accept Smith's proposal. That needed sorting out. And what happens during the morning of the 26th of March, UTC, is essentially, I mean this with no disrespect, a horse trade on that one issue. That's all. So it's very important not to, it was important, I'm not saying it was important, it wasn't important, the parties clearly thought it was important. The question is whether it was intended to form then and there a contract, and our submission is it didn't. But one does need to see what the scope of the disagreement between the parties at that stage was, and that's all it was. Sixthly, the email contract which the owners now rely on left and leaves unresolved centrally important issues as the parties would at themselves at the time have appreciated. Now this is important because the fact that there was enough agreed in principle to make, the fact that there was enough agreed to make a contract does not mean that the skeletal nature of what was agreed is not highly relevant to the question of intention to be bound. They're separate questions. Now, it's quite unclear, and as your ladyship and your lordship don't need reminding, this was a huge public casualty of the highest possible profile. It's completely unclear on owner's case, it always has been, whether Smit, under this contract, the contract owners assert, were required to provide any services at all. Is it a walking to York contract? That's, by the way, owner's pleaded case. If they were bound, and I think I heard this morning some attempt to try and tie in the services back to the services identified in the commercial proposal, which was a very difficult submission with respect. If there were services that Smit were required to perform, what were those services? The remuneration terms that were agreed in a vacuum. To what did they apply? But as the judge said in paragraph 75, there's an obvious link between what you undertake to do and what you expect to be paid for it. Now, if one reads, and I'm not suggesting we read them now, the judgment of paragraph 16 to 21, one can see Mr. Justice Andrew Baker, if I may say so with great respect, slightly toasting my learned friends on the spit, because he pointed out the inherent confusions and alterations in the owner's case as to what the services which Smit was contracted to provide, what they were. And the owner's case was and remains a muddle on this. Now, this is not, so that makes it inherently less likely that they would have agreed such a contract. So this is not a theoretical or lawyer's objection, because it will be seen that this was one of the very topics on which what Smit was required and willing to do and on what terms, on which the owners and Smit were unable to reach agreement. And not just that, of course, but when I say terms, I don't just mean the scope of the contract, but the standard of care. You might think it obvious that the standard of care would be reasonable care. Oh no. The owners insisted on best endeavours, which is the standard of care under an LOF. So in the salvage context, there's nothing strange about best endeavours, but the wreck-hour is reasonable care. And owners, when they actually got down to it, so they wanted best endeavours. So they also fell out on terms of payment. All the things that one could have predicted, simply by looking at the commercial proposal and looking at the skeletal contract on which my learned friend relies and seeing what wasn't in the contract on which my learned friend relies. It's all the things that Smit had insisted on nailing down at the outset from the first commercial proposal. Seventh, and now a submission in its own right, the judge has found as a fact, paragraph 77, that it was reasonably to be expected on both sides that the detailed contract would be finalised promptly, with Smit expecting it to be finalised, I think it's signed, on the 26th, and the owners knowing it. So I ask rhetorically, what was the need for the interim contract at some earlier point on the 26th? This is an important point, and it's not surprising that owners have withdrawn their previous concession at trial that the wreck hire contract would follow the two emails, quote, in a very short space of time, unquote. We've read that in our skeleton, paragraph 73 too. And of course, the difficulty with that and saying that there wasn't time is, I must limit the number of times I make this point, the contract was agreed. So to say there wasn't time for it to be agreed is an unpromising submission. And the judge records that it was agreed, as I told you before lunch. So there was no need for an interim contract, and there's no, although my learned friend now says there's no rational basis for the judge's finding in paragraph 77, there's every rational basis, including the points I've already made, and my Lord Justice Popplewell's point that people could be expected to apply a little bit of effort to agreeing the necessary contractual terms on wreck hire, given that this was rather an important commercial situation. Eighth and last, owner's case on the ultimatums is a chimera for a number of reasons. First, it entirely begs the question at issue on this appeal. To take the most explicit one, Smit's email at 0843, which is S1 tab 74, page 142. That required, quote, an agreement, close quote, by no. There was an agreement, and the parties were seeking to make an agreement. No dispute about that. The question is, was the agreement intended to have contractual force, or was it intended to be the resolution of a knotty point on remuneration, namely the bonus, with everything else that was important to follow almost immediately? So to say, oh look, this is an ultimatum that you've got to reach an agreement or else, attaching the agreement, in quotation marks, to an ultimatum is exactly the same question as if there hadn't been an ultimatum. If the parties reach an agreement, the question is, was that intended to have independent contractual force or not? So my learned friend's argument begs the question. But second, and here's perhaps the point on the ultimatums, because this is a question that this court is going to have to decide. What we say is that these ultimata did not objectively signal what would have been a radical change of approach on Smit's part. In this sense, Smit had gone to all the trouble of rapidly drafting up and tabling their revised commercial proposal as the express basis for contracting, repeating what they'd done in less detail the previous day. And what my learned friend has to say is that they were now abruptly signalling a willingness to abandon that entire careful and professional modus operandi in favour of some ill-defined and skeletal alternative that was fraught with problems. This would have been a particularly pointless thing for them to do, given their expectation on reasonable grounds that the contract would be signed that day, the detailed contract. Now, in fairness to my learned friend, he recognises that he has to persuade your ladyship and your lordships that there was, as he puts it, a fundamental change of approach. Those are the words he used in his submissions. That would have been a completely irrational thing for Smit to do in the circumstances in which they found themselves, not least because, taking a step back, it was owners in this case who were over a barrel. It was their ship that was blocking the Suez Canal. There was a great deal of adverse coverage and publicity, and one can only imagine what the sort of pressures that were being brought to bear on them. But they were the ones, if one's looking at the situation in which the parties found themselves, who were in, shall I put it this way, a more time-sensitive position. And so it would have made even less sense for Smit, who quite clearly had developed what this court may think of as a sensible strategy, which is, this is complicated, this is difficult, it may go on for some time. Let's work at pace and get everything sorted out up front. Why on earth, I ask, would they change horses so suddenly? It wasn't as if they hadn't realised that they would be contracting tugs when they made their commercial proposal the previous night. I confess I was slightly confused by my learned friend's submissions on. He said that in fact the tugs weren't under charter in the morning of the 26th, and the parties would have known that. Well, if that's right, then the need for what he called Smit to have what he called protection would have been less acute. But in fact, they didn't need the protection of a contract. It's not right to say that Smit needed the protection of an interim contract. Quite apart from all the other points I've made, they could claim the costs of hiring in the tugs as out-of-pocket expenses under common law salvage, as long as those tugs contributed to an eventual successful refloating. Didn't need a contract.
That would have been a matter of some uncertainty at the time.
That precisely brings me on to my next submission. It would, with respect, my lord, not have been a matter of much uncertainty for these reasons.
Is this number 9?
Sorry?
Is this number 9?
No, I said 8.
Continuing.
I haven't thought of one over lunch.
Well, right.
Well, I was just yes.
No, sorry. This was going to be my fourth sub point under. This is still submission 8. And I said at the outset that the owner's case on the ultimatum was chimerical.
Yeah.
The last point I was going to make is that factually it's exaggerated, and I'm just about to explain why. There had been several unsuccessful attempts to refloat this vessel. The need for heavier tugs than had hitherto been brought to bear had been acknowledged internally by owners. That's S1, tab 55, page 82, identified in Smith's commercial proposal and in their draft salvage plan. Those are pages, S1, pages 85 and 94, tab 56. These were perhaps, and they identified 2 tugs. I mean, Smit, I don't want to blow my client's trumpet, but they are
I'm sure
professional
they'd be very
salvage.
happy if you do so.
It's not. But when they said, well, you need heavier tugs, and here are 2, the owners, as I say, had already acknowledged this. The owners requested Smit to contract for those tugs. That is, as owners concede in paragraph 27 of that skeleton. So it was, of course, the future's always uncertain. Lord Justice Popplewell will no doubt say to me. But there was a problem here. All the previous refloating attempts had failed. It was clear that more powerful tugs were needed. Owners accepted that. Owners asked for them. And one can see what Smit thought about this. Smit were quite happy to agree that they would earn no reflotation bonus if the vessel refloated on the 26th of March before the tugs got there. So one has some idea about what their view of the prospects of that happening were. And when, if you want to see what actually happened in the reflotation, I think my Lord Justice Popplewell asked for this. The daily progress report for the day of reflotation is in bundle S2 tab 141, page 344. What happened was, if I can summarise rather than ask.
Sorry, just give me that reference
Yes,
again, please.
S2
Yep.
tab 141, page 344. It's a report over several pages, and it's a data. It's one of a series of reports. And what happened was, and of course, they didn't have crystal balls, the parties, but this was not surprising. Within a few hours of the Smit tugs, the ALP Guard and the Carlo Magno being attached on the 29th of March, the vessel was pulled free. And that was, my lady, my lords, the 7th attempt at refloating. Just to give you the detail on that, there was a reflotation attempt on each of 23rd, 24th, 25th, high tide and low tide on the 26th, and one attempt on the 27th. So, 7th time lucky with the tugs. Now, I can't put it higher than saying that this was likely to be what would have happened, but the degree of uncertainty which my Lord Justice Popplewell put to me, whilst I can't eradicate it entirely, one needs perhaps to be realistic about this. These were perhaps the greatest experts in the field saying this is what we need, finding it, contracting for it at owner's request. They'd have got common law salvage for it in any event, unless the vessel had been pulled free either never or before the tugs arrived. Either very likely. Right, those are my 8 submissions, and what I'd like to do now is to go back through some of the documents in a little more detail. I know you've seen them once, but they're important, and we say they're dispositive. If one sees them in the right spirit, they're dispositive of the appeal. Now, we've already looked at, but we need to have a look at S1 tab 22, page 39. As I say, within 24 hours of Smit first learning of casualties. Now, this is described in the subject as being a commercial proposal. Those words are not just for you, I'm not criticising, those words are not in the judge's appendix. So you might just care to note that if you're using the judge's appendix, it's not completely, it's nearly exhaustive, but not completely exhaustive. And there are 1 or 2 omissions. And this is described as, in the first line of the body of the email, the commercial way forward. Commercial meaning what? Commercial as opposed to technical. The technical way forward is what happens on the ground. The commercial way forward is the contractual arrangement between the parties. And what they were summarising, as they say, was the daily hire arrangement following discussions earlier today. Now, this proposal made obvious that at this stage, at any rate, Smit required this level of detail to be agreed. That included the need for wreck hire to be identified, as it was, and logically filled and amended, which means at that stage they hadn't done the job on the wreck hire, but the form was to be wreck hire and it was to be logically filled and amended, otherwise as per standard form, if there was nothing in this agreement which varied it. Very importantly, Smit made clear that they neither saw the need to nor were willing to contract on some vaguer and more skeletal basis, which did not cover, for example, scope of services, standard of care and timing of payments, all of which were covered in this proposal. Now, on the question of scope, in this proposal, Smit made clear that it covered refloating only. So other operations, such as lightering and dredgering, were not covered. You've read this document once, so I'm not going to take you to each line where, as it were, what I'm saying is, but if you don't find something, or you don't remember it, I'll show you where it is in the document. But lightering and dredging, the exclusion of them is at the foot of the page. The pulling only is in the 3rd main bullet, 3rd sub-bullet. Because this proposal was superseded, it's not necessary to examine it in too much detail, but you have the fact that it, for the first time, proposed a reflotation bonus, 25% at that stage. It addressed the terms of payment, in other words, when things were going to have to be paid by, as well as the amount of payments. It addressed the scope of the services. It addressed the personnel involved. And in stipulating that the contract form was going to be wreck hire, it determined that the standard of care in the provision of services and in the avoidance of pollution was going to be that of reasonable care. That's clauses 2 and 24 in the wreck hire pro forma. See S1 tab 56, pages 106 and 115. So this was, though it was only one page, it covered a lot of detail and crucial detail that was missing in what I will call owner's contract. Subsequent exchanges on the very same day demonstrated the importance of defining the scope of the services, because at 16:30 on this same 24th of March, Smit sent an email about tug options, referring to engaging tugs in the refloating, pulling only operation. That's what they said. And Captain Sen that evening asked whether that included pushing as well as pulling and scouring. We don't need to, well, it's S1 tab 34.
Could you give me the page as well?
Yeah, yes, I can, sorry, 58. So Captain Sen wants to know what's included. And you may think that the answer that David Wisser of Smit gives is a professional one. That's a tab 35, page 59. The next tab. He says, with refloating by pulling only, we actually mean all kinds of operations by tugs only, and we explicitly mean to exclude refloating by means of lightering, etc., dredging. So scouring and pushing by the tugs would be included. And then this, my lady, my lords, we will certainly make sure that this is clearly stated in the wreck hire, so that all parties are crystal clear in the intentions and expectations of the services. So this commercial proposal, which I showed you a few minutes ago, was an offer. It was described by Smit to Sen as the offered commercial basis. That's S1 tab 24, page 43. And as you know from reading the judgment and it's common ground, this could have been cleanly accepted and been a contract. But there was no response, substantive response. And so we go on to another document you've looked at, S1 tab 42, page 66. Now, we have to unpick my learned friend's submissions on this with a little care. If you could just familiarise yourself by casting an eye back over the fourth bullet. This email was sent against the background of the first commercial proposal, not the second one. We just need to bear that in mind. And I think it's common ground that it was sent in reaction to Sen's request to Smit to engage a tug, and in the context of Smit having proposed a reflotation bonus the previous day, about which owners had so far said nothing substantive in 19 hours. And what Smit expressly require, following the language of this document, is a formal response to our commercial proposal sent yesterday. And that was said to be important. And that was clearly required as the next step. At the end of the message, as one does when one's driving a point home, Wisser repeats, says that he's looking forward to your feedback on the above points. And that is what would provide, quote, some kind of assurance, close quote, that the parties were on the same page. A metaphor which is not mine, but had been used by Smit to send in an email on the previous day, 24th March, at 13:15. S1, tab 29, page 49, after the original commercial proposal had been sent. Tab 29, page 40. The issue in this case is that there was a false, sorry, the issue in the first sentence here is that there was a false rumour that the vessel had refloated. Same page. Now, my lady and my lords, the words some kind of assurance mean what they say. The provision by owners of a clear indication that the parties were aligned in their basic expectations. If owners were going to turn down the idea of a bonus flat, then the sooner that Smit knew it, the better. But here's what one needs to focus on. These words do not refer to some skeletal contractual engagement far short of the commercial proposal which Smit had already tabled. Now, Smit went on to say that they also required discussion and negotiation of the wreck hire agreement. The way it's put in this email, the agreement of the commercial proposal and logical completion of the wreck hire form are opposite sides of the same coin. But now look at what owners say. Owners say that this email envisages a two-stage contractual process. That's their skeleton, they say it twice, 24 and 44.2. In other words, there are two successive contracts contemplated as the way forward. Now, my first submission is, no, it doesn't. And that's a matter of reading the document. But the second is more important in a sense, although the first is not a formal point, it's my primary case. Supposing I'm wrong about that primary case. The two stages which, let's assume now that two contractual stages are being contemplated. The two stages are, one, agreement to the commercial proposal, two, completion of the wreck hire contract. Because that's what Smit's whole modus operandi has been. But what my learned friend says is, oh no, the first stage is not agreement to the commercial proposal, it is conclusion of a vague contract falling far short of the commercial proposal already tabled and leaving everything else up in the air. And two, we agree on that hypothesis. Now, this is, that is, as it were, the important, the first point I made is just a matter of impression of reading the email, but the second point, one's got to see what's going on here. My learned friend has, if I may say so, smuggled in his 26th of March contract as the first stage. And he says, well, look, here we are. They want a two-stage contract. But if they do want a two-stage contract, the first stage is agreeing to the commercial proposal. In fact, it's not. It's something called some kind of assurance, which doesn't sound like a contract at all. But if it is a contract, what must it be? Answer, the commercial offer that Smit has already made. And it is perverse, moreover, my lady and my lords, to construe the email as entailing a successive track strategy in which the parties agree an outline, incomplete but binding contract, and then set to the wreck hire form, with everything of substance hopefully agreed in the second stage. Because supposing it couldn't be agreed at the second stage, as indeed is what happened, the parties on this hypothesis are still bound. But bound to what? Smit have said what they want. They want, that Smit have indicated the degree of detail they want. They want the commercial proposal degree of detail. And that they're willing to contract on. But nowhere can one get out of this a willingness on either side to contract on the basis of some skeletal agreement in the pious hope that everything may thereafter be agreed, but if it can't, the parties are locked together in some contract which the courts will have to sort out one day, and meanwhile, who knows what's going to happen to the vessel. Now, can't remember whether my learned friend took you to it. I apologise if he did, but the next tab is after this email of 729 is tab 43, page 67. Certainly not mentioned in my learned friend's skeleton. So after this 729 email, what we get is from Captain Sen again. And he says, thank you for your email, which is the one we've just been looking at. I think all I need to read is, reverting with your wreck hire offer as soon as possible. So again, Captain Sen understands that the offer which Smit is making is to contract on wreck hire terms, as per the commercial proposal. Sen says he will revert with it, meaning specifically in relation to it. So what Sen is envisaging happening is owners engaging with Smit's commercial offer, including discussion of the form. And a few minutes after this email, my client Smit send owners' solicitors the commercial proposal we've already seen. Just to give you the reference, it's S1 tab 45, page 69. So, what my friend cannot get out of the 0729 email is anything which supports the contract for which he argues on this appeal. Quite the opposite. And what then happens is a European day passes, and in the evening in Europe at 21:40, as your ladyship and your lordship have seen, the revised commercial proposal is sent. It's S1 tab 56, page 83. Now what's happened? The owners have not come back, either substantively on the reflotation bonus or on any other aspect of the commercial proposal that Smit had gone to the trouble of drafting at speed. And Smit have upped their work rate because in the course of the working day, they have refined and worked hard on their proposal. And now what they send forward is the complete package. The commercial terms, both as set out separately and as incorporated into the rec hire form. The drafting completed, the logical amendments done. This is an offer, and as we will see, it is understood by the owners to be an offer, not that that's a surprise. We'll actually see Captain Sen changes the heading in the email when he replies to it to include the word offer. So the position is that it's 33 hours by my calculation since Smit's original offer, and now they're making, since having heard nothing, a revised offer. Again, their terms are on the table. Nothing to suggest that they're willing to contract on any different basis, quite the opposite. So, this document, tab 56, which we will look at in a little detail, is sent. And where I ask rhetorically is the proposed two-stage contractual process now. Because my learned friend says there was a two-stage contractual process in the 0729 email. He says there's a two-stage contractual process on the 26th of March, the next day. But where's the two-stage contractual proposal here? The agreement, sorry, I'm repeating myself. All the work's been done. Now, if we look at page 83, what Dave Wisser says at the top of this email is, as promised, and in order to move forward with this matter. Those words, by the way, are also not quoted in the judgment or in the appendix. They're not the most important words in the document, but they're not insignificant. This was the way forward. And so what is attached is called, on page 83, a commercial proposal. And if we go forward to page 84, in the third paragraph under Dear Sirs, it's headed a commercial proposal. It says, in order to provide you with a solution to refloat the vessel via the involvement of Smit, we hereby provide you with our revised commercial proposal. Now that really could hardly be clearer. What it's saying is, if you want Smit to help you, these are the terms on which we are willing to help you, and no other. I don't mean to imply that Smit would have been completely unwilling to negotiate any detail on any of the terms, but this is their firm and clear position. And if you want to move forward with us, you do so in this, contractually, you do so by addressing this document and in this way. Now, a lot of detailed work has gone into this, as one can see, if one turns the ensuing 30 or 40 pages. But as I've already submitted to your ladyship and your lordships, my learned friend is committed on this appeal to the proposition that between about 8 o'clock in the morning and midday, Smit completely abandoned this entire modus operandi in favour of what I've already called a pious hope that on the basis of a skeletal contract, everything else could be agreed. Now, what follows, still on page 84, is they say, they refer below the heading in the middle of the text, they say the initial brief commercial proposal was already provided to you yesterday, and following onwards discussion, we can summarise the main terms and conditions as followed. Now, I think I'm right in saying that that's the only use of the expression main terms that crosses the line. I may be wrong about it. The only one that crosses the line between then and the point at which my learned friend argues that a contract has been concluded on the 26th. But it's not really part of my case to become to get over complicated about what it is or isn't a main term or a main terms agreement. That is to paraphrase the question which is for the court. Did the parties intend to be contractually bound? They may have thought that the remuneration terms were the main terms. That's not the question. The question is whether they intended to be contractually bound, given what wasn't agreed, given what they said, and given what had preceded it. But then we have some underlining in the original, because after the reference to main terms in the first bullet, the contract is the rekha, and then underlined are the words, for your review, please see enclosed the proposed draft wording of the contract stating all relevant contracting details. Now, why is it underlined? Because it's important. And it emphasises the importance of this aspect of the process. But my learned friend says that the very bit which that Smit underlined is properly to be regarded as what he calls a secondary and inessential exercise. So they're underlining the unimportant bit. Nor, my lady, my lords, is this some quixotic punctilio on the part of Smit, because on the 27th, the vessel's hull underwriters make clear to Smit that they are taking the same attitude. If one looks at S1, go forward, keep a finger in this, but go forward to tab 104, page 203. and your ladyship and your lordships may not find this very surprising. This is Mr. Isawa of Mitsui, the Hull underwriters, in the morning of the 27th, to Smit, and also to Captain Sen. And they say at the first bullet, as this incident has attracted attention of MSI's top management and may result in huge loss and cost, we must pay very careful consideration to the contract to obtain internal approval. So, can we go back to S1 tab 56? I'll canter through this because it's not the sort of thing one can spend limited time going through the detail of. The main terms comprise 7 bullets, not counting the sub-bullets. The first is the underlined bit we've already been looking at. The third defines the scope of the services. At the foot, or it's called the nature of the services, that's the scope. And what's interesting here is that this time, lightering and dredging is included if required. The other thing that's, so this is very important because what happens is that they include lighting and dredging, but they increase the reflotation bonus from 25% to 35%. What a surprise. The scope of the services is enlarged. The size of the reflotation bonus sought is enlarged. Hardly surprising. But my learned friend says, oh no, they were quite content to agree the remuneration terms, but the question of the scope, that could be sorted out later or something else. The judge said at paragraph 75, remuneration and scope are obviously connected, which is one reason why reaching a landing on remuneration alone and not scope points against the existence of a contract. That is, so that is scope. Then there's also periods when the scopic rates will apply, timing of payments, and then we have, and I haven't got time to go through it in detail, the amended rec hire with additional clauses. We then have the part 1, which is the box part of the rec hire contract, including the various provisions. There's provision now for a diving survey. That's page 103. There are detailed provisions about the timing of payments. That's page 104. There's a provision for 8% interest in the event of non-payment within 2 days. That's page 105. All of this matters. It's impertinent for an advocate to expect a busy court to read these documents in its own time, but I think that's what I'm going, nonetheless, to have to hope that you do, so that you can just see what all of this has been done, all of it's proposed. Of course, if owners don't like the idea of having to pay invoices in 2 days, they can counter. But this is the basis upon which the parties are going forward. In fact, they couldn't agree. They never did agree about the period after invoice when owners would have to pay. Smit said 2 days. Owners came out with 14. Smit then said 5, but we want an extra 1.5 million if you're going to have 5. And that was the end of the negotiation. So they weren't very close on that. These are large sums of money, and they're important points. We've looked at the standard of care, but let me just pick that point up. If we go to the rec hire form part 2, page 106. The services, clause 2, the contractor agrees to exercise due care in rendering the services. And clause 24, on page 115, this is pollution. And it's to say the contractor shall exercise due care throughout the performance of the services. And as I've already told your ladyship and your lordships, that was a bone of contention because owners came back and said they wanted a best endeavours obligation. I'll just give you the reference, S2, tab 122, page 230. Also in the appendix of paragraph 133. And again, Smit had, even in relation to what you might call the standard form part 2 of the wreck hire contract, not the boxes, but the standard form supplementary clauses, made amendments, and those are obviously of importance to it, to Smit. Now, I rather rushed through that, and I'm sorry for having done so, but you get the shape of the proposal. And this is on the table on the evening UTC on the 25th. Relevant contracting details. And once more, Captain Sen replies promptly within an hour at 22:28 on the 25th at S1 tab 57 page 121. At the foot of this page, you can see page 83. What, sorry, you can't see page 83. You can see what was also on page 83. And Captain Sen's reply, what's the first thing that's interesting is the subject. The subject is ever given aground in Suez Canal, Smit Salvage, draft agreement, commercial offer. If you look at the subject of page 83, as it were, at the foot of the page, at the foot of the same page, or indeed page 83, it's a different subject. The first bit's the same. And what must have happened, there's no other explanation for this, certainly none that I can think of, is that as you can do when you're replying to an email, you can change the subject, or add to it, or alter it. So Captain Sen's in no doubt what this is. This is a commercial offer. He says so. He actually changes the heading of the email to reflect his understanding. And he then says, we acknowledge receipt of your email and documents. Then there's something about the Alp Guard. We will also revert on your proposed commercial offer as soon as possible. What then happens, as I told you immediately after lunch, is that Sen forwards the package to Mitsui, who forward the package to SKK. And owners thus have the whole of the Far Eastern day of the 26th of March to consider it while Europe goes to bed. That's what it does. And that is why the judge is right if we look at paragraph 60 and 62 of the judgment in saying that an imminent response to this proposal would reasonably have been expected. That's page 69 of the core bundle, tab 3. But perhaps we could simply, in the interest of time, look at tab 62. The morning of the 26th of March 2021 arrived with no contract in place, but a detailed set of terms on the table, proposed by Smit the previous evening and sent to owners the previous evening, UTC. to which an imminent response could have been reasonably expected. Well, that's not a finding for which there's no rational basis. That's a finding that's absolutely inevitable. But when dawn breaks, there is no response. And so what we've got to is a situation where we're awaiting a response on the contractual document, the commercial offer, but there still also hasn't been a response on the, as it were, particular issue of the reflotation bonus, because that doesn't come until 8:16 that morning. Time goes by, and the owners have not got back. And so then we get the first ultimatum, using my friend's
I
terminology.
see this at page 127. The title is changed again by the addition of the word urgent. I don't know
Yes.
if that has any significance, probably not.
127, did you say?
Yes. If you
Well,
compare-
Captain Sen is a great changer of email headings, is all we can infer from this. Well, he's keen. This is the email, by the way, that shows owners instructing Smit to engage the Owl Guard and giving effectively future instructions to retain the Carlo Magno. Meanwhile, he adds, reverting on offer shortly. Now, they've still not heard anything about the reflotation bonus. Not a dicky bird. They didn't react to the 25%, they haven't reacted to the 35%, and that's important because it's clearly essential to Smit as a necessary but not a sufficient condition of a contract that they know what's going on and that the terms are agreed. So then we get S168. Yeah, sorry, 136, I apologise. Now, this is an internal document, so I think I'm right to say that the word main terms does not cross the line unless one infers, which is perhaps a rather generous inference, that Captain Sen, when he emails Mitsui, is using the, or is to be assumed necessarily to be using the ipsissima verba of the telephone conversation he's reporting. But it doesn't matter to me. I think I made this clear. Because if main term means the commercial offer made the previous evening, well, that's fine by me. But even if it means just the remuneration, it doesn't actually throw any light, in the light of what I previously submitted, on whether the parties are intending to enter, whether in particular Smit are objectively intending to enter into a contract. But the right inference at this stage is that main terms means what it means in the commercial proposal, which is where the term main terms was used about the 7 bullets. Secondly, at this stage, you note that there is no time limit to this ultimatum, which, among other things, might strengthen the view that it was intended to refer to the full proposal. But thirdly, a point which I'm afraid I keep making, there's no signal here that Smit is entirely changing the modus operandi in which it has invested a great deal of time and effort and commercial good sense. Namely, this is a difficult case. We need to get things sorted out up front, not leave them for another day. So what then happens is that Captain Sen, at 8:16, at long last, comes back on the reflotation bonus. That's S1 tab 70, page 138. And owners, as I say, the other reflotation terms don't matter. They've apart from a mistake about scopic and cost, there's been no dispute from the outset that Smit are going to get remunerated on scopic rates, and out-of-pocket expenses will have an uplift of 15%. So
That had already been agreed, had it?
well, yes, it has. It's been
Not specifically though.
well. It was actually agreed right at the beginning on the 23rd and the 24th. But
Just remind me of where I see that.
yes.
I thought it was simply part of the commercial offer that hadn't been responded to.
No, that's right. Let me just. I may struggle to give you a reference off
Page
Top
28 and 29.
28 and 29.
In
Thank you.
tabs 11 and 12.
Thank you, Mr. Jacob.
What?
Tab 11.
Tab
Yes,
11 and
thank you.
12.
This is an email from Captain Sen to Dave Wisser. And do you see the paragraph beginning although?
Page 28. Tab 11.
Page 28.
And then it's
And 29
page
last
29.
paragraph.
Yeah.
Stage.
28, so pages 28, 28 and 29.
Very helpful.
So that is what there's never been any dispute that that is the basis upon which the basic remuneration is going to be structured. That's why I say the row come the morning of the 26th is only about the reflotation bonus. And so I'm back on page 138, aren't I? Tab 70. Page 138. And we've traced this through. I don't want to, the detail in a sense doesn't matter. Owners counter with a less generous version of the reflotation bonus than Smit has proposed.
Sorry, may I interrupt? Just so I've got it clear in my head. So that we have, as we've been told, page 28, obviously what were verbal discussions, because it talks about a telephone conversation at 7:09 on the 24th.
Yes.
And then what we see is that conversation confirmed in that email and the one you took us to at page 29.
Yes.
They are then incorporated a
Into
few
the
hours
commercial
later
offers.
at 12:03 into the commercial offer. So
There's
that's
a
where we
slight
see the
confusion. An irrelevant confusion apart. Those are givens all the way through.
I understand that, thank you.
Fine.
Yes, I think my misunderstanding, I thought it was in response to the
No.
contractual offer you were saying that it had been
No, I
accepted,
may- I
but
just
it was
didn't
something that
explain
was
it.
agreed before they got to the stage of a written offer.
But that's why, my lady, I say that the argument on the morning of the 26th was about a very narrow topic.
Understood, I just,
Yes, but that's why I say it.
So subject to the wrinkle, which doesn't matter for your argument. But out of pockets were scopic
Yes.
50%.
But there was a
cost plus
confusion
50.
about that,
Yes.
but nobody seems to regarded that as significant one way or another. I mean, it was, in fact,
28 is ambiguous on that.
yes. Well, but I'm going to get this the wrong way around. I think the Smith's commercial offer were cost plus
Yes, cost.
15%, and Captain Sen got that wrong. But he got that doesn't.
He came back with scope plus, and Smith said equity because that's
I
better for us.
But I think it. Well,
internally.
yes, maybe.
Yeah.
But sorry, 138.
sorry I distracted you.
No, it's helpful if I may say so that your ladyship did. 138 at the end of the email. We look forward to your confirmation acceptance of the above. In other words, let's sort out the basic terms of remuneration, and then we can get on with doing what the real meat of the task ahead of us is and has been since your first commercial proposal, and certainly since your second one, which is ironing out the rec hire draft. So now, what then happens is, because of the mistake that I've just been telling your ladyship and your lordship about, and another one, namely that which my learned friend mentioned that the captain said had misunderstood his owner's instructions. He then, rather lamely, has to go back at tab 72, page 140, and cancel the previous email, 138. So not surprisingly, Smit, there's a note of exasperation in Smit's response. In Shield's 843 response, which is tab 74, page 142. And what now happens is that Smit say, well, this has got to happen. Agreement has got to happen by noon Dutch time. That's tab 74. Or we'll stand down. Now, what is meant by agreement? This simple business of just agreeing, which is a neutral word, the terms of remuneration. Not only are owners apparently not willing to accept the 35%, but there seem to be other problems as well. And so Captain Shields proposes a deadline. But what I'm inviting your ladyship and your lordships to accept is that we still have not, on the language of this email, reached a situation where Smit is saying, don't worry about the commercial proposal, we can worry about all that later. We want a contract, and we want it merely to be a contract on remuneration terms and nothing else. Of course they want the remuneration terms agreed. They want an agreement. I don't pretend they didn't. But the question is, what did they want? What objectively were they after as far as a contract is concerned?
And what's your case on what they were after by 12 o'clock Dutch time? What do you say agreement was intended to mean?
Oh, well, the agreement,
everything by 12 o'clock Dutch time, or
no, agreement on remuneration. The reason I hesitated is because this is Jody Shields, and when Richard Janssens sends his email at 10:37, he's taking a step back, because that's the one in which he says, I'm retabling our offer, the offer of last night. My lord, there's an air of unreality about these ultimata. There was evidence before the judge, and it may not surprise your ladyship and your lordships, there was evidence from Mr. Janssens that this was a bluff. And this was a very important casualty. Smit had a reputation to keep. And the idea that they would walk away from the most public casualty in the world is perhaps not a very plausible one. And but that's all right, that's what people do in commercial negotiations. So it's not entirely realistic to take these at face value. But that said, I think I can pass on from the page 142.
before you do so, is this the, on your case, this is the first time that Smit asked for something which they've called an agreement, meaning something less than all terms, is it?
Yes, I think it is.
I think it is from what you've been telling us.
And the context of that is that they appear to be, they're negotiating about the remuneration bonus. Emails go back and forward, and then a proposal is put, and then it's withdrawn and cancelled.
Are they negotiating about the remuneration terms? I mean, before 138, have they had any agreement to anything?
It's 138.816. Yes.
Yeah.
No.
So we've had, I think, on your case, we've had these are commercial terms, i.e., everything. very clear at page 83 and 84, you say, got to have agreement on everything. Don't get anything for a while. They get, we're prepared to agree these terms.
Yes.
And then the response is, withdrawn. And then the response is 142. We need to have an agreement by 12 o'clock Dutch time. That you say is now intended to convey an agreement on a moment ago. You said what they were negotiating about, but they haven't. They haven't really been negotiating.
That's
up to
true.
That point, just on remuneration terms. Have they? They haven't done anything.
No. I mean, not it isn't very clear,
Does it matter
the
for your
reason
case
why-
which it is?
sorry.
Does it matter
Not
for your
well,
case?
no,
which
it doesn't.
is?
Perhaps that's why I haven't worked it out. Because for a number of reasons. The first is because what happens at 10:37, which is quite clear. And the second is my Lord Justice Popplewell's subject to contract point. Unless there has been, unless there is signified by this exchange an intent to abandon the idea of contracting as a first stage, as the contract, the terms of the commercial proposal, which, by the way, owners constantly say, yes, we realise we've got to respond on this, then it doesn't matter. We're still in the realm where Smit are requiring the commercial proposal to be the basis of the contract, and are await. And owners keep saying, yes, we'll get back to you.
It says, as discussed, but there's no reference in the judgment, is there, to any discussion which might cast light on what was being talked about?
My lord, in the bundle, at the back of S2 are the witness statements, which, as the judge rightly said, are far longer than they need to be because they just recite the correspondence. But as I think my learned friend said, there's very little that fills out or fleshes out the emails themselves. I'll give further thought, if I can, while I'm making submissions, or more realistically, I'll be told what to say by somebody about my Lord Justice Popplewell's question about 142. But in my submission, it doesn't matter. My primary submission was that what they were trying to do, somewhat exasperatedly, given what had what the rather confused picture, was just give the what I might call the negotiation on the remuneration package a kick. But on the question of what was going to constitute a binding contract, nothing had changed. So then we get paragraph 1032. Sorry, we don't get paragraph 1032. We get the email at 1032 at tab 78. 46. And the terms are refined again. The reflotation is refined again. This introduces that no reflotation bonus if the vessel is refloated on the 26th. And Captain Sen ends by saying, we look forward to your confirmation acceptance of the above. We can then start ironing out the wreck hire draft agreement so that the same can be signed at the earliest. And your ladyship and your lordships have the judge's findings on what that meant and what that implied. So that's 1032. Now, so on that basis, I ask again, why was it so important for Smit to have an interim contract? There was no need for it. What they wanted was to get the bit, is for the parties to be on the same page about the remuneration package. That they did need. That didn't have to be contractual, that just had to be an understanding between two respectable commercial entities. We understand that this is the basis. And then, now seeing it in its context, what my learned friend relies upon, but unfortunately, one of us must be wrong, because I rely on it too, which is the email at 147, tab 79. And this is the managing director, Mr. Janssens. There have been a number of people, Jody Shields and Dave Wisser, but this is the managing director saying to Captain Sen at 10:37, please allow me to refer to the telephone conversation that you had with Jody this morning, in which it was agreed that you would get back to us with a decision before 11 o'clock, after which we would then repeat our position in a formal message. With that time frame having lapsed, I checked with Jody and understand you've just had a telcon with him, which is why I would like to repeat our offer as submitted last night and make it clear that your recap sent below is incorrect and not on the table, as our offer of last night supersedes that. Now, my learned friend says, oh, that doesn't mean our offer as submitted last night. It only means one small part of it. But it's not, that won't do, because what Mr. Janssens is looking at the overall contractual picture. And what he is saying is, you know, we wanted LOF to start with, and we're either going to have a commercial agreement as per our commercial offer, or we're going to have a Lloyd's open form. And that antithesis of commercial agreement versus Lloyd's open form is stated twice in this document. First, in the first paragraph, where it says, alternatively, we remain open to LOF terms. And then in the second paragraph, where he says, with the world watching and so on, failing the requested confirmation of either a commercial agreement or Lloyd's open form, we may be left with little choice. Now, a commercial agreement in that sentence means the same as our offer as submitted last night in the previous paragraph, and both of them are contrasted with the same thing, namely Lloyd's open form. And what the managing director is doing is saying, take a step back. We made you an offer last night. We're putting that offer back on the table now. Yes, of course, it covers things like remuneration bonus. But that's what we're doing. So, I mean, the remarkable thing about this case is that the two principal emails upon which my learned friend relies at 11:35 and 11:40 take place under the aegis of a restatement of a commercial proposal made an hour beforehand, the commercial proposal itself having been made at 21:40 the previous evening, and being an iteration of a previous commercial proposal. And yet what my learned friend is saying is that Smit have changed horses in quite a radical way.
But presumably you would say, looking at the substantive paragraph, which talks about, as you say, placing the offer on the table again, then the fact that it goes for the avoidance of doubt, specifically relating to the bonus, you would say, I suppose, that that's clarification of one term of the overall contract on which they rely.
Yes, and particularly the words specifically relating. In other words, what we are generally doing, I'm grateful, I'd underlined those words, but then completely forgotten to make a submission in relation.
I made an excellent junior in my time.
The general point is we reiterate our offer, and then and by the way, there's an aspect of that specifically relating to the reflotation bonus. It's 35%. So this properly understood, as we respectfully submit, this is a very difficult document for my learned friend, because he's got to. If there was any doubt about it, actually there isn't. It revivifies the commercial proposal made at 21:40 the previous night. And it makes clear that, in a sense, the remuneration package, the reflotation horse trade is a sideshow to the contract. It's got to be agreed, but it's a sideshow. And also, I hope Mr. Janssens, who's in court, will forgive me for saying this. The world watching paragraph is a respectable way of saying you need us more than we need you. And then lastly, I think we need to look at tab 80, page 1, for 8. But I think we looked at that with my learned friend. I don't think I have a separate submission on that. So we're on the verge of the two emails at 11:35 and 11:40. So the key elements are, we know how public and significant and serious this case is, and we know why it was in both parties' objective interests to make sure that the contractual terms were agreed as quickly as possible and in as much detail as possible. The situation was urgent, no doubt about that, and the judge finds that in paragraph 44, Roman 3. But what is important is that although this was an urgent situation, this wasn't a ship drifting towards the rock with danger to life and limb. This was a case in which there was time for a full agreement to be reached. And the judge found that. In paragraph 40.
Back to 147, it's my fault.
Sorry.
Can I just go back to page 147?
Yes.
Mr. Janssen refers to make it clear that your recap as sent below is incorrect. Is that a reference to page 146? Which is where the 25% bonus.
I think it's a reference to page 146.
The reason I wondered is that if one goes forward to 148,
Yes.
and shortly afterwards says to actually said, our message is just crossed. Which suggests he might not have seen it when he sent 147.
I'm very nervous about this because 1048 at the top of the page may well be 1148 because the second half of 148 is 1132.
That's from Sen.
Yes. I'm just nervous that it might be that the document he's referring to is is that 14? Can that be one? No.
146 is
Is it 146?
Gone wrong with the Dutch
148 is
email
146.
timings because 147 is simply sent at 10:37 Dutch time.
no, UTC.
We've got the same email,
11:37.
haven't we? One marked at 10:32 and the other marked at 11:32.
And again, I think there was
10:37 UTC.
it's,
Even though he's in Holland.
Yes.
yes. If you look at all of the agreed appendix, they've agreed the UTC equivalents.
Printed out here.
And if you look at, so 1032 is UTC, and I think we agree that 146 and 148, the 148 at the bottom is 146, it's just that one does have the Dutch time in it.
I don't know whether your lordship has a question. I feel very unlikely I'll be able to answer it.
No, all right. It may not matter.
Can I just come back to the judgment, paragraph 41? The judge found that this was an urgent case, but not a case in which there was no time for a full agreement to be reached. That's very important, because that explains yet another of the rather loose arguments. Oh well, they must have meant to enter a contract. But anyway, the urgency cuts both ways, my lady, my lords, because it is a factor that could reasonably be thought to induce owners to get on and agree detailed terms, especially when the pressure was principally on them. This is still part of my step back tour d'horizon. It's common ground that Smit had already contributed to any future salvage of the vessel. In the usual way, owners plead that the contribution was minimal, but they admit that Smit had already provided services in the form of technical assistance and consulting with the Suez Canal Authority. It's a fact that 5 personnel from Smit arrived at the canal on the morning of the 25th of March. We've seen the salvage plan that was prepared and provided by Smit to owners on the evening of the 25th of March. That's part of the package. It's not in the bundle, but it was in the documents below. Smit had assisted in emptying water forward compartments of the vessel to assist with future refloating. The tugs have been found and engaged at owners' request, which were thought to be necessary and highly likely to contribute to a successful salving of the vessel. So Smit were most unlikely to leave this scene empty-handed, contract or no contract. In fact, it was inconceivable that they would leave empty-handed as long as the vessel was salved. If the vessel became a total loss, then they would get nothing non-contractually. Moreover, a non-contractual salvage claim had the capacity to be significantly greater than a contractual salvage claim, especially if the salvage effort was not prolonged.
Is this your explanation for why the urgency seems to have gone out of it from Smit's point of view? That the previous reflotation attempts had failed, and
Yes.
either they were going to be, so Smit, you say, we're now in a very strong
Yes.
bargaining
There were no powerful tugs any nearer than the ones that
contract
Smit.
anymore. Is that it?
Well, I don't quite accept the
One of
premise
Mr.
of.
Parsons' submissions is that it all goes very quiet.
Well, it
after
doesn't
the
really.
20th.
There is a chaser in the evening. In the evening at 1756, I don't really accept that there was my learned friend called it, I think, a radical change of tone. It's not right. They go on chasing, Sen and owners go on saying they're going to come back. Or in fact, what they say, which may be part of the reason, is Sen, with what turns out to be false optimism, says, well, there's nothing very major to worry about anyway. There's a chaser at 1756 on the 26th.
1756.
On the 26th.
And 18.
On the 26th?
On the
Yeah,
26th.
and 1802 is the reply. Captain Sen says, well, there's nothing remarkably major, is it?
It's those 2 tabs then. Nothing remarkable.
Nothing remarkably major to amend. And
Conversely, there's a delay in relation to the charter of the ALP, which is a major expense,
They're
yes.
heavily involved in that.
because
Yes.
there's a problem with the terms that
yes,
the tug owners want.
it
It was all over the weekend, wasn't it?
yes. I mean, I don't want to be. It's important for Smit to have got the agreement that they get on the remuneration terms. I don't want to imply otherwise. Of course it
Well,
is.
certainly,
But
Nelson sounded pretty pleased
Yes.
in the tone of the email of the 26th of March
Yes.
at 11:40. Very
um,
much appreciated. Very, very best regards. You know, there's a real tone of
well,
relief. And
they've agreed remuneration, and I don't
I
mean
think
to
it's
imply
said
that's
that
not
they've
important.
agreed a contract. Is how
Sorry.
that's part of Mr. Parsons' tone submission. I think that marks the agreement being reached and everyone taking their foot off the gas a bit. Well,
No, what they've agreed, what they've reached agreement on is remuneration.
I know
terms.
that's
that I
your
accept.
case. I know that's your
Of course that's important. But the countervailing factors, which I've been taking you through, make quite plain that seen in the context, that can't possibly be regarded, and I won't repeat all my submissions, as a binding contract. A, it doesn't really work, and B, it's quite clearly what the parties, it's not the route down which, contractually speaking, the parties were intending to proceed. So that's the debate between us. And the point I was just on is that
Just to interrupt you, there's one other reference on that. Robert relies issues. Don't worry, you mentioned it.
yes, I don't think I need to mention that again. Thank you. The point I think I'm can summarise is that the situation as at 11:35, 11:40 was not one in which, viewed objectively, Smit would find it necessary to have a binding outline contract on vague terms at the earliest moment to protect their mobilisation. And as you know, we say that they showed every sign of wanting to nail down the detail since midday on the 24th of March. And you won't have lost sight of the fact that the full contract was to be agreed, expected to be agreed, imminently. In other words, my lady, my lords, in terms of how to reach a contract, the parties were entirely agreed on the process by which they would do so, namely by engaging with and agreeing, maybe negotiating on the basis of, but engaging with Smith's commercial offer. Be a very extraordinary case if the parties were found to have made a skeletal contract after a detailed contract had been prepared, exchanged with the solicitors, and in circumstances where it was reasonably envisaged that the detailed contract would be agreed, as my learned friend said below, within a very short space of time. Words to that effect. So we have reached the emails of 11:35 and 11:40. They are at tab 81 and tab 82. And I mentioned earlier that both of these emails are claused in the sense of being qualified. These are my friends, I think, although he doesn't actually quite identify, but I think these are his offer and acceptance. I certainly understand the judge to have understood his case, or his, Mr. Jacob's case in that way below. So there is the, and although that, there, we've got page 149, and although it sets out all the remuneration, well, some of the, not even all the remuneration terms, nothing to do with terms of payment. The only contentious point is C. And, well, you're now very familiar with these documents. At the end, we look forward to your confirmation. We can then start ironing out the rec hire draft agreement so that the same can be signed at the earliest. And then on page 150, but it's important, as well as the sentiment in the first sentence, it's also important to look at what follows. Richard Jansen says, "Thank you, Captain, and confirm," which is very much appreciated. "I shall inform our teams accordingly, and we shall follow up with the drafting of the contract upon receipt of your client's feedback to our draft as sent last night." So the point that Mr. Jansen is making at that point is right. We've got the remuneration agreed. But what next has to happen, and still hasn't happened, is you haven't responded on our commercial offer, our commercial proposal. That's what's now got to happen. So if there has been a fundamental change, as my learned friend argues, of tactic or approach on behalf of Smit, it hasn't lasted very long, because here at 11:40 is Mr. Jansen saying, you need to get back to us on our commercial offer of last night. You haven't done so yet. When you've done so, we can deal with the contract. So, in fact, of course, no change. So, we say it's impossible to regard this as a clean acceptance of what was in any event not a contractual offer. Far from abandoning his own commercial proposal, or his Smith's commercial proposal, Janssen was yet again reiterating it, just as had been done in his email of an hour earlier, at 11:37. And at 11:42, tab 83, page 151, Captain Sen says, "Thank you for your prompt confirmation. I will be in touch with Jody and Dave regarding the contract wording." And now it's 12:42, and I think that's 11:42. Is that right? I think it's 11:42. That.
Yeah, 11:42 UTC.
Yes, 151 is 11:42 UTC. And within half an hour, behind the arrows, I accept, but within half an hour, Mitsui and SKK will have agreed the whole thing. But that is the 6th occasion on which Captain Sen has promised to be in touch on the contract. So my learned friend's point appears to be that it's not until 1756 on that day, this is tab 90, page 184, that there's
Sorry,
another
which page
chaser
was
from
that?
Smith.
Sorry, which page was that?
184,
Very much.
tab 90. And here, about 6 or perhaps 7, I'm not sure, hours after the previous one, Dave Wisser says, reference is made to the below exchanges. Could you please indicate when we can expect your company's detailed response on the draft rec hire? We would obviously like to finalise this soonest. My learned friend calls that a complete change of tone, or perhaps he means the gap between that and the previous one is a complete change of tone. They were doing it like that. At tab 91, page 186, Captain Sen says, "Thank you for your email. There's nothing remarkably major to amend." Well, that turned out to be quite wrong, unfortunately. And at the next tab, page 187, Wisser replies 3 minutes later, "Thanks for the swift response. Good to hear no major issues. Look forward to your soonest full feedback." So they're still pressing. And if we then go forward to the next day, tab 102, at the foot of the page, there's a long email from, and the yellow is Smith's response. And in the last paragraph, they say, "Furthermore, we are still awaiting feedback on our contract, which has not been signed. Yet here we are, doing our utmost to support, sending an inspection team and taking 2 large tugs on hire. Furthermore, our salvage superintendent is assisting the crew the whole day," and so on. That's not the reaction of a party that thinks it's secured a contract. What it's saying is, we haven't got a contract, you haven't got back to us, but we're still helping you. As I say, my lady, my lords, there was never any disagreement about process. Both sides manifested to the other the unmistakable intention that they would enter legal relations on the terms of a completed, agreed wreck hire contract and no other. Now, my learned friend says in his skeleton at paragraph 44, everybody knows that when you don't want to make a binding contract, you say subject to contract or subject details. And they didn't, so they must have wanted a contract. My lord, my lady, my lords, arguments that the parties could have used words would have put their objective intention beyond doubt are rarely persuasive. Certainly not in this case. The judge was quite right at paragraph 68 to say that this was, in substance, a subject details case. All the way through. It didn't change. Smith had made plain that that's what they wanted. And I can't immediately think of any case in the books where a party has put into play a long-form contract, made absolutely clear that that is the basis upon which it is willing to contract, and then finds itself having somehow entered some quite different contract in the interim and after that contract's been tabled. It's a very striking issue, and it's a sign that something would be wrong with a finding in accordance with my learned friend's appeal. My learned friend made the point, he certainly made it in his skeleton and touched on it today, that the court should find a contract because it was in both parties' interests to enter a contract. At best, my lady, my lords, that is an other things being equal point. No doubt when two parties are negotiating, other things being equal, it's a good idea if they can enter into a contract. But if they can't agree, or if there are circumstances which suggest that they haven't, then the point simply doesn't move the ball. My lady, I just need to finish the story a little.
How are we doing for time?
Well, is the court going to sit until 4:30 or what are the?
We were going to sit till 4:15, but with your amazing advocacy, I suspect you've just persuaded us to sit till 4:30.
Well,
You've got meetings.
I'm so sorry. There was a debate among counsel as to when we weren't quite sure what the regular court hours
The
were.
regular hours are 4:15.
Right.
Count to
Well,
that. We nearly always have
somebody owes me 5p
tedious
then.
meetings after court, but I think we're all available to sit till half
Well,
past 4.
I can take what the rest of. If I haven't persuaded you by now, I'm unlikely to do so in what remains. But
You must cover what you need to cover. I'm just conscious that
no.
we must give Mr. Parsons a little time to make his to do his
Yes,
reply.
well, yes. I've covered the meat of what I want to cover, but I just need to deal with this because one looks. We're agreed on this. One looks at the whole run of the correspondence, even though there's an argument that a contract was made at a particular point. You already have the fact that the parties fell out over the very issues which were covered in my client's commercial proposal, which wasn't accepted, but weren't covered in the contract which my learned friend says was formed, and were then attempted to be agreed as part of the RECA, and they weren't. So payment terms, I've already mentioned this. I'm not sure to what extent you need the detail on this, but I mentioned where those payment terms were to be found in the commercial proposal of the draft RECA. Smit had asked for 2 days, you remember. That's box 13 at S1 tab 56, page 105. I told you already that Sen countered that it would have to be 14 days. That's S2 122, page 222 and 229. Then Smit said, well, we'll accept 5 days, but with an extra 1.5 million as well. S2 128 at 295.
Now, how does this help us?
Well, it was objectively obvious at the time that there was something wrong with a contract in terms which didn't define a contract which didn't defy key terms. And that is a reason why it was objectively the case that the parties did not have an intention to be bound at this stage, because it was desirable, and Smit had sought to nail down these terms at the outset, and they are nailed down in the commercial offer, in both commercial offers. My learned friend says no, what the parties did, and therefore must be taken objectively to have done, is to contract on the basis that they agreed nothing except remuneration terms. To which I say they're very unlikely to have agreed that, because experienced commercial parties would have known that that was fraught with difficulty. And this submission is, that's exactly what happened. It's a proof of the pudding. Now, in a sense, I don't need the proof of the pudding, but it is what happened. I'll take it shortly. You remember how important it was to define the scope of the services, how that was that issue about whether or not scouring and pushing were going to be covered, and how Mr. Wisser had said at page S1, tab 34, page 59, that the exact scope of the services would be clearly stated in the rec hire contract, so that all parties are crystal clear in the intentions and expectations. I mean, it would be a total disaster if there was a misunderstanding between the salvors and the ship owners as to what was supposed to be done to unblock the Suez Canal. It's hard to conceive that responsible commercial parties would have entered into such an agreement. But my learned friend's case is that they did. You've got the point on the standard of care. I think there are other points I could make, but you have the shape of the point. Now, I've taken a chronological approach to the exchanges, and I don't really need to develop others of my points, but and you obviously have the fact that a critical point here was the existence of a draft full agreement in existence. And as I said, the work's already been done. But what owners say in their skeleton argument is that there were, quote, compelling commercial reasons, unquote, for the parties to have agreed the contract in the emails. And we respectfully submit that there were no such compelling commercial reasons, because the whole thing could have been wrapped up at the same time and in short order. And as I say, owners argue that the court should find a contract on the 26th of March because it was in both parties' interests to have one. But that point counts against owners, because if it was the case that there was a strong commercial impetus to form a legally binding contract, and given that, as owners realise, Smit were requiring owners' response on the basis of the commercial proposal, it could reasonably be expected, as the judge found, paragraph 77, that the parties would move to conclude that contract in a very short time. The fact that, although my learned friend says that there was no rational basis, skeleton paragraph 59, for the judge's finding that it was reasonably to be expected that a concluded detailed contract could be agreed promptly, for all the reasons I've previously given, not least that it was agreed promptly, we submit that that is an impossibly ambitious submission. And that is the answer that the judge gave to owner's point made orally this morning and in the skeleton at paragraph 58, that it's significant that the refloatation bonus would not be paid if the vessel was floated on the 26th of March. Well, the judge's answer to that was that it was expected that the contract would be agreed by then anyway. But there's another answer to that point, which is, it's a very lawyerish point, to say after the fact, well, this might not have been a binding contract, but it's converted into being a binding contract by the idea that one of its terms would only take effect if it was a binding contract. These were responsible commercial parties trying to establish common ground. All that the agreement made clear was the parties' understanding that if Smit, if the vessel refloated on the 26th of March, then there was no question of a reflotation, presumably because Smit would be held by that stage not to have contributed sufficiently to have earned one. But to say that that's a serious pointer in favour of a binding contract is hardly something that is likely to have struck the parties at the time.
I thought your earlier submissions would have led you to make a slightly different point, which is, this comes for the first time on the morning of the 26th of March as a suggestion from owners, and doesn't seem to have caused any particular interest on Smith's side.
Because they thought it was not going to happen.
Because they thought it wasn't going to happen.
Yes.
In which case, that's entirely consistent with them thinking, however long it might take to finalise the terms. We don't need to worry about that. That doesn't indicate an intention that we've got to treat these as agreed terms. If it's not going to happen, we can just ignore that.
Yes. I don't think it's a good point.
That's obviously not a good point. Or you would
No, on the contrary. Sorry, I was sorry, I was trying to deal with two things at once, which is at least one too many. I'm so sorry about that. It's certainly the case, and I have submitted, that Smit were completely unworried by the fact of not earning a reflotation bonus if the vessel refloated on the 26th. My difficulty with accepting what your lordship puts to me is not because I disagree with it, because I always have some difficulty in I don't mean this in a discourteous way. I always have some difficulty in understanding how my learned friend really puts his point. But I keep being told by my team that it's a point that I need to address. But I never really see. I never really see what it is. But it certainly would be the case, my lord, that if, as we've submitted, there was no question of the vessel being refloated on the 26th, then it simply was a matter of no consequence.
The big point against you is if the reflotation bonus was a big point in remuneration terms,
Yes.
that your clients were anxious to make sure they got their 35%, then it wouldn't be much good having an agreement to that, which might disappear immediately if it wasn't a contractual term.
Well, then I see where your lordship's observation comes in. I never really quite understood why that would be such a terrible thing from my client's point of view. They're still there. They can still ask for a reflotation bonus. If the ship hasn't refloated, the parties are in no different situation. Anyway, I don't think I
And
made
if the
much
ship
progress.
if the ship has refloated, contrary to their expectation, with the assistance of tugs, which they've done nothing to attract,
Yes.
then they might not see themselves as being on very strong commercial grounds
No.
anyway.
That's absolutely right, which is why. But since they clearly thought that wasn't very likely to happen, and they were the experts, they were quite. Sorry.
Yes, well, that's
Yes.
that's what you say, isn't it?
Yeah. I think I probably dealt with everything I want to say about part performance. It's obviously, this is salvage, it's obviously a different world, it's obviously a case where all the cases depend on their own facts. And I would say this, that it's conceded by owners in their skeleton at paragraph 39, that the idea that part performance implies the existence of a contract doesn't apply in subject to contract cases. That's paragraph 39. And I have made the submissions that I think I need to make on the ultimatum. First, the point that the ultimatum begs the question as to what is meant by agreement in the ultimata. Secondly, that Smith didn't, their attitude didn't imply a change to the basis upon which they have been proceeding. Thirdly, that the contract was going to be finalised in very short order. And fourthly, making a threat which is a bluff is hardly unknown in commercial negotiations. I gave you a reference to Mr. Jansen's witness statement saying that they were never in fact going to withdraw. And that's S2 tab 145 at 381, paragraph 36. My lady and my lords, unless I'm told,
Yeah, precisely.
Oh.
It's just with the guys, and we need to qualify something.
I've got to qualify something. Thank you.
Anything else?
Just on that last point, the bluff not being unknown, did the judge make any finding about that part of Mr. Jansen's evidence, or indeed how the position should have been understood from the owner's point of view?
He did not.
Because-
He did not, but I would say that it doesn't require a great deal of commercial nous to suppose that Smith were hardly likely to walk away from this casualty. But, what they said, that was the evidence, and those are my submissions.
It's not your submission, though, that the owners should have presumed it was a bluff.
Well,
It seemed to be what you were saying a moment ago.
yes, I am saying that. People do make make those sort of representations in commercial contracts.
A bluff which the other party appreciates as a bluff is not a terribly strong negotiating weapon.
That may well be right.
And it would have had to be put to Captain Sen, but he realised it was a bluff. I don't know whether it was.
Well, I think you probably got my reply submissions on that point, which was it didn't cross the line. A negotiation of bluff isn't a proper bluff, and it was never put to Captain Sen at the trial, and there's no finding in the judgment on that. The other point that's linked to submissions of fact was there were quite a lot of submissions on the reflotation basis that Smith did not think that was a problem because they did not believe that it would reflate before the tugs arrived on the 29th. There's no evidence of that either. That's not a finding in the judgment. And insofar as there is any evidence, if you go to SB2 at page 356, this is Captain Sen's witness statement. It's the last sentence of paragraph 37. When, and if you go to the previous page, you can see this is under the 26th of March. He says, at that point, there were signs of vessels being refloated during the day, with the SCA engaging more tugs. And you recall that there were discussions about Smit chartering the Red Sea Brigand, but that in the event, the SCA took that tug. So what was happening on the ground was the SCA, who were in charge of the reflotation, were chartering in more tugs, and they were having reflotation attempts each day. And on the 26th, the evidence is, Captain Sen, that there were signs that it might refloat. And that is the commercial background against which the ultimatum is made. The position is that by the 26th, there was a chance that this would refloat. And that is why I submit the ultimatums were written. And Smits were very keen to ensure that they had a contract that would give them remuneration for the tugs they were chartering in circumstances where there was a risk that this vessel would refloat before the tugs arrived on site. And that is what is the change on the 26th. And that is the basis of the ultimatum. And that is why it is said, if we do not have an agreement by 12 noon, we will demobilise. It's not a bluff. It is there is a chance this could refloat. We are committing to very substantial expenditure, not a few people. Therefore, we need an agreement on remuneration. And that is the basis of the messages. I'm not going to go back over them. In the end, you have to look at our submissions and read the things.
The judge didn't make any findings about that. I was just looking at Captain Jensen. That wasn't his evidence about the reason for it.
No.
So,
No. But what was being put to
you
you?
can make submissions as to what might have been in the parties' minds. But the submission that it was because there was a possibility or likelihood of reflotation on the 26th that the ultimatum was given was not, Captain Jansen's evidence and was not the finding of the judge.
No, but that's why I was very careful in my submissions to keep you looking at what crossed the line.
Yes.
And what crosses the line is an ultimatum that we will demobilise unless we have a remuneration agreement. That can only be objectively because there may be a risk that without that, we won't get paid. That's as far as I put it in my submissions. I was really answering the points that it was anticipated between the parties that, or for part of the contractual construction, that there wouldn't be a reflotation in any event. The next point I wanted to just take you to very briefly was my learned friend showed you page 28 and 29. Now, these were controversial at the trial, but they're quite interesting because they're an answer to my lady's questions about what was the agreement on personnel. And if you look at 28, this is on the 24th. So this is before rec hires on the table, before there's any question of highly complex terms, before there's any question of whether it's due diligence or best endeavours. What is being agreed here is, although we had verbally discussed the costs of new personnel will be Scottish rates and out-of-pocket expenses on usual uplift of 15%, the team needs to attend on board, assess the grounding, assist Master and S.A. with on-site recommendation for quick reflotation. And then at 29, my learned friend showed you the message, which the final paragraph, this is when they're pressing for LOA. Having said the above, we do appreciate the current discussions and instructions, and we will continue to mobilise our team towards the casualty based on below daily hire scheme. And then the other one linked to this is 31, is a discussion between Smits and Nippon. That's going to be complex because W.K. Webster just now confirmed that at this stage, when no LF has been signed, only a Smit team is allowed to mobilise to the site on a daily hire basis. Now that looks like an agreement that if you mobilise, you get paid on a daily hire basis. That is what is being said here. And that is an agreement at an early stage. Now, if you recall in the judgment, there was an argument about whether this was pleaded and could be relied on. But that was due to a misunderstanding as to what was being put. It wasn't being suggested that this agreement was being pleaded as a response to a salvage claim. What was being said is that there was an earlier agreement to mobilise, and it was simply being used as an example, very similar to the Lord Clark case, of where you can effectively have an agreement to mobilise on agreed rates. And that's what was going on here. You can actually see it's being treated as an agreement, that if we mobilise, these will be the rates. No need to have anything more, no need to have a more detailed contract. And that's, we say, the way it would work. So I see the time. I'm
No,
going.
no, you must have your reply. We've said we'll sit till 4:30, and we will.
We won't sit till 4:30. But if you just give me a second to double check.
No, take your time.
I'm going to deal with two small points and then finish off. First of all, paragraph 77 of the judgment, which is where my learned friend refers to the judge's finding that it would be expected that it would be signed that evening. So I could ask you to cross-reference that against A98. So let me just, a bit properly. It was reasonably contemplated the detailed terms of the contract could be finalised promptly after the emails agreeing the remuneration term. Indeed, Smit was understood on the defendant side to be looking to finalise a contract and get it signed within the 26th of March, and then he just says that didn't occur. If I'd ask you to look at the message, which is at page 102 at A98, what was being said there was we were asked by Smit to sign with today for the firm order for tug that had been issued, but I explained although we agreed with the contract, signing would take place on Monday of the following week or thereafter.
So sorry, where are you?
So I'm in page 102, paragraph A98. But although the judge quotes it was understood on one side by midnight, the full quote was actually what was discussed would it be on both sides. The next point I just wanted to come back on was my learned friend, when he dealt with the assurance email, he used the phrase on the same page. And he said, well, that's not my phrase, that is a phrase that was used by the parties. And he showed you page, I think it was 49. Now, what he says is there we are, all the more reason to ensure we get on the same page. But this is, with respect, an incorrect point. This is nothing to do with the contract or contractual terms. Because if you go back to the previous page 48 to see what this is a response to, Richard, reference below, you've been misinformed. The vessel is still aground and has not moved. Please be wary of a lot of false information being floated around. So I don't know how much of the bundle you read, but there were discussions about whether there had been an LOF contract at an early stage, whether the vessel was refloating or not. And this comment about being on the same page is about what was actually happening. This had nothing to do with a commercial contract. So that point doesn't assist my friend. And in the end, what it really comes down to is the ultimatum and what the parties meant by main terms in the morning of the 26th. And the first time that main terms is referred to is you saw on page 136, but as Mr. Jacobs pointed out during my submission, you have to refer that back to 129, and it's pretty clear that main terms was therefore something, or one can reasonably infer main terms was something that was discussed and identified in that email as being the remuneration package. And we do submit that the 26th does mark whatever was going on before, whatever my learned friend says about the full spectrum, that the main terms are what was defined in page 129. And it was done on that basis, for all the reasons I gave, that Smit were concerned to ensure they would have remuneration in the same way as they'd had on pages 28 and 29, but in relation particularly to the tugs and to sort out the reflotation bonus. And with great respect to my learned friend, on 147, he says, oh, well, that is a repeat of the night before. But I respectfully ask you to look again at, if you look at 147 and then 148 and what follows, it's quite clear that that once the owners come back and agree the reflotation bonus, Mr. Jansen is happy. He doesn't then say, well, thank you for confirming the reflotation bonus. Now please reconfirm that you agree all the rest of the terms. So that's why I submitted that 147 properly read is limited to the reflotation bonus. Because if it was as wide as my learned friend says, then he would have come back and said, well, what about all the rest of this? Because how are we going to have an agreement by 12 o'clock UTC unless you agree all of it, if that is what had been intended? And that is why I submit that by the morning, it was focused between the parties simply on the remuneration, probably in the expectation the rest of it would be simple and would be sorted out by the lawyers. But that is what they were concerned about, and that's how the ultimatum works. And that's why when one reads this whole run, you should reach the conclusion that it was a main terms contract with the rest to be sorted later. And those are my submissions. Thank you.
Yes.
Yes, one of Mr. Gazeman's points was why do you need a binding agreement on main terms if you think that the rest of it is going to be sorted out imminently? Do you want to say anything about that?
Yes, because they wanted an agreement by 12 noon, or they were going to demobilise. The only agreement that could be sorted out by 12 noon was the remuneration, and that works for both parties. Smits are then safe, knowing that they will be paid while their tugs are still steaming to the casualty, and owners are protected because they now know they have the mobilisation. You have to link it in, that particular point, my lord, to the ultimatum that there had to be an agreement by 12 o'clock. And that's the way we would say it works.
Thank you very much.
Thank you very much. Well, can I thank you all very much indeed for your submissions, and all the legal teams who I've no doubt put in an enormous amount of work into the preparation. And also, if I can, from my own point of view, thank whoever was put together the bundles, because for about the first time in about 10 years, I was able to follow the emails. So I'm profoundly grateful. Whichever poor soul spent hours and hours and hours working out the strips of emails and the email trail. So I'm extremely grateful. It won't surprise any of you that we're going to reserve our judgments. You'll receive a draft of our judgments in due course. I can't tell you precisely when. For typographical and minor infelicities only, please, not as an opportunity to re-argue the case. May I remind those who will be dealing with the distribution of draft judgments of the terms of the embargo, which I know most of you will now be familiar with, but it's extremely important in all cases, and particularly cases of commercial sensitivity. Otherwise, I hope you'll be able to agree any other matters between you, particularly a draft order, but we'll deal with anything else in writing. So thank you all very much indeed.